The next case come before the court is in Re A.M. Good morning.
Good morning, Your Honor.
Give us just 1 second. All right, it may not be quite as important with you this morning since nobody's arguing on the other side, but we do have the 15 minutes, up there so you can review them and see where you're at on the monitor. So,
All right, that's nice to
okay.
know.
All right, so you're flying solo today, so you have 15 minutes.
Thank you. This is basically your typical legal custody case that comes out of the juvenile court. Prior to coming up here this morning, I spent the morning reading about the last 10 legal custody cases that have come out of this court, and kind of starting at the end of my argument because it's apparent to me that it's incumbent upon me as father's attorney to demonstrate that this is the exceptional case where the finder of fact clearly lost its way and created a manifest miscarriage of justice in denying father's motion for legal custody if I am to prevail on the brief that I filed. And what troubles me about the fact pattern in this particular case is it arose as a dependency case, and it was the mother's conduct or the activities that were occurring in her residence that led to the filing of a complaint. There were 3 children. As it pertains to the child of this case, it was a dependency allegation. Father was represented by counsel. He had nothing to do with the grounds for the removal, so I guess he stipulated to the dependency. And that obviously is an issue because the court is, as you're well aware, that the standard of parental suitability is no longer like a governing concern. It's the best interest of the child, which is what the court has to focus on. And in this particular case, I would advocate on behalf of the father that he had no relationship with the child for pretty much the first 7 years of the child's life, because I believe when the child was 3 or 4 years old, there was an allegation made against him that he sexually abused the child, and during the course of the juvenile court proceedings, it was determined that that allegation was unsubstantiated. So during the course of the case, the father worked his case plan, successfully completed all of the objectives that were there, and again, as the court is aware, that although case plan compliance is commendable, it's not dispositive of the issue, because then you have to apply the best interest factors, both under 2151.414 and under 3109 of the revised code. And in this particular case, the guardian ad litem was recommending that the child be placed with the father. This agency, Summit County Children's Services, had filed a motion that the child be placed with the father. However, right before the hearing date for the legal custody, the guardian, not the guardian ad litem, but the attorney that was appointed for the child, who's waived the oral argument today, as I read the transcript and understood it, because there were 2 siblings by 2 different fathers that found out that they weren't going to be living with, returned to their fathers, that the 3 children had grown up together and they were all placed with the same legal custodian. As a result, the 9-year-old child, I believe she was 9, got to the point where she didn't want to be separated from her 2 sisters, so she changed her mind. The guardian and the agency proceeded to trial, advocating that the father should get legal custody.
And I read that in your brief, but is there anything, was that evidence actually presented at the hearing about that, as to why she changed her mind?
I didn't reread the transcript, but I think I cited to the transcript, or maybe it was in the Schubert Agarwal's brief, because I remember seeing something this morning about it.
Just when I read it, it just sounded like we were hypothesizing.
Well, I wasn't involved in the trial court, so I got it somewhere out of either the transcripts or the pleadings.
Right. Okay. That's fine.
That I would have reviewed at the court file. But, you know, admittedly, this is a tough case to decide at the trial court level, because as I indicated, you know, if I'm advocating for the father, which I am, the dependency was not due to any conduct he engaged in. He successfully completed all his case plan objectives, which was he was paying child support, he had appropriate housing, he could meet the child's basic needs, he was employed, he consistently visited, he participated in the child's counseling. Apparently, it wasn't clear to me, but the child at some point was diagnosed with post-traumatic stress disorder. I don't know if that related to the abuse allegation, which was later unsubstantiated, but they also claimed, the counselor claimed that the child had anxiety disorders, and it seemed to me like what carried the weight with the trial court, both the magistrate and Judge Theodosio, was the allegation that the child didn't adapt well to change, meaning if she had been placed with the father, she'd had to change schools, change residence, be separated from her sister. I get that, but at the same time, there was a change from the mother to the non-relative custodian.
Wasn't the mother's death something that occurred during the pregnancy in this case as well?
The mother's,
Death?
I
I
think
don't
it was
recall.
the father died or something. Maybe it was in the other case. I know somebody died, but that we had today.
That might be in the other CSP. As far as I know,
Never mind.
this mother's still living, but I don't represent her. But, and, you know, the reason father was initially estranged from his child was because of that sex abuse allegation, which, as I indicated, was unsubstantiated. To father's credit, and actually everybody in the case agreed, father visited with the child consistently and bonded with the child, and prior to the case, the inception of the case, the child was actually bonded with the paternal grandmother, as were the other two stepchildren, or, yeah, I guess it'd be stepsisters, I should say. And as I indicated, the agency and the guardian were on board with father getting legal custody, and my reading of the transcript and the record was that father was willing to facilitate visitation with the two sisters. But, you know, when you apply the law, me personally, I see this inherent conflict out there, because to me, the right for a natural biological father to raise their own child, they say it's a fundamental right, it's constitutionally protected. I guess it's not absolute, because what the court focuses on is the best interest of the child. But I just think in the totality of this case, when you factor in he has that fundamental right, he complied with his case plan, there's no question father was suitable. Nobody, you know, under the law, I guess it's not a consideration, but it's a fact.
Now, had he progressed to overnight visitations?
And I reread the Schubert Agarwal's brief, and in there it said it went from supervised to monitor to day visits and then overnight visits. So
And that's what
I
that
didn't
actually
like.
means, staying overnight.
Yeah, I think that's in her brief somewhere, as I recall. I read it a couple hours ago. But
I read that too, but I just couldn't remember whether it actually progressed to that point. I know that was the plan.
yeah,
We'll find
I
it.
didn't reread the.
That's all right,
Yeah.
we'll find it.
You know, and we're dealing with a non-relative here, which, you know, I read some case law, in fact, I copied it, that came out of this court, that even they say, courts have held that appropriate relatives should generally be given priority over non-relative in legal custody decisions, but blood relationship in and of itself does not control the trial court's best interest determination. And just the same way when you talk about the suitability of the father is trumped by the best interest standard. I guess it just boils down to whether the court, given the status of the case law, especially coming from the Ohio Supreme Court, feels that this is an exceptional case or not, that the trial court lost its way. I believe it did, because I think there's nothing more father could have done here. And I think the father's fundamental right to raise his own child as to the care, the custody, and the management of that child should be given more weight within the legal system. You know, that's my argument to this court, that, you know, the best interest, I guess if you looked at it from, well, you know, we return the child to the father, it's going to uproot her from her two sisters, and it's going to be changed in her school and her home. But that was the same, well, it wasn't exactly the same consequence that happened when the agency removed the children from the mother, because I think all three kids ended up with the non-relative proposed custodian, or the person that eventually got custodian. But, I mean, you know, that's a balancing test, and Judge Teodosio and Magistrate Menlick made the decision they made. It was contrary to the recommendation of the guardian ad litem and the agency's position. For what it's worth, I'm making the argument that, you know, the father did everything in his power, he was suitable, and I think actually one of the things that the focus is on the current parenting ability of the parties, and I think father is not only suitable, but he's exceptional. I mean, he's done everything. I mean, there's nothing in this record that says he can't parent his own child. And I guess in closing, I would just ask the court to take that into consideration as you apply the law to the facts and arguments that have been made in this case.
Thank you. Thank you so much for your presentation to the court, the argument, and we will take the matter under advisement. You know the rules. We'll send you and CSP and the child's attorney a copy of our opinion, and it will be posted online as well.
Okay.
Thank you.
Thank you.